Hi, thank you for if you left comments and or questions on my first video. As a brief review on the subject matter discussed in the first video, patents are legal documents filed with the United States Patent and Trademark Office, USPTO for short. Patents describe and protect inventions. Patents give you the right to exclude others from making, selling, using, or importing the invention. People often think of a patent as a monopoly in the claimed invention for a limited period of time. Patents are valid for 20 years from the earliest filing date. In exchange for the monopoly granted by the U.S. government for a period of time, the patented invention is published so that others can learn from the invention and potentially build on that knowledge. The act of filing an application with the USPTO enables you to write on your product the words "patent pending." These words may lend credibility to your product, may increase sales, and may cause competitors to think twice before copying your product. Further, if you are granted a patent, you can prevent others from copying your invention. My name is Andrew Abramson. My site is patentsprofiler.com. I'm a type 1 diabetic and I'm on an insulin pump. I was diagnosed at age 5. In March 2017, I was in a diabetic coma. I was in the coma for about 1 month. My main issue is speaking. I've been a patent attorney for over 15 years. I have worked in a few law firms. My last firm, which is a large firm, I was of counsel, which is a step below partner. Now I will discuss trademarks. There are two ways to qualify as a first user of a trademark. 1. Actual use. Being the first to use the trademark service mark on a product or ad that is distributed in the marketplace. Or 2. Intent to use. Being the first to file an intent to use application with the USPTO, provided that 1. The applicant files the trademark application before the mark is used by another party, and 2. The applicant later puts the mark into actual use and completes the registration by submitting an additional form and paying an additional fee. The USPTO website is www.uspto.gov. Additionally, 2 different and separate businesses can use the same mark as long as no customer confusion is likely to occur. As a general criteria, if the underlying product or services are unrelated, customer confusion is unlikely. The PTO keeps two lists of trademarks that it registers: the principal register and the supplemental register. These lists have the following information: 1. The trademarks. 2. The owner of the marks. 3. The dates the marks were registered. 4. Types of goods or services identified by the marks. And 5. Other information, such as how the marks were described by the owners in the application. Placement on the principal register gives a trademark far more protection. Some of the ways to register on the principal register are: 1. The mark must be used in commerce for actual use. If the application has been filed as an intended to use application, the mark will not be registered until it is in actual use. 2. The mark must be distinctive enough. The mark must be distinctive through use over time to serve as a product or service identifier. 3. The mark may not be confusingly similar in a place where confusion would be likely. 4. The mark may not include the title of a book, play, recording, or movie that is a single issue artistic work, unless the idea has become well known over time. These are just a few ways to register on the principal register. The benefits to register on the principal register are: 1. Exclusive nationwide ownership of the mark in connection with certain goods or services. 2. Federal registration gives the registrant the opportunity to use the federal courts to enforce their rights. 3. Official notice that the mark is unavailable to all later users. 4. The right to put the R with the circle after the mark, which puts users on notice that the mark is registered. 5. The right to remove certain challenges if the mark is in continuous use and substantially exclusive for 5 years after the registration date. And 6. A legal presumption that the registrant is the owner of the mark. The supplemental register is for marks that are not distinctive enough for the principal register. There are benefits to being on the supplemental register. First, if a mark continues in use and is on the supplemental register for 5 years is evidence of acquired distinctiveness, which can help get on the principal register. Second, the owner of a mark listed on the supplemental register can use the R with a circle around the symbol, which signifies that the mark is a registered trademark and may deter others from attempting to use such a mark. If a mark is a non-distinctive mark and on the supplemental register, it cannot be placed on the principal register without proof of secondary meaning. The main implication of a non-distinctive mark on the supplemental register is that the mark is not protected under the Lanham Act, the federal trademark statute. It may, however, still be protectable. 3 bodies of law that govern trademarks are: 1. The Federal Lanham Act. 2. State statutes, and 3. The common law. The national system of trademark rights has many benefits over state trademark law rights. For example, 1. Federal registration on the principal register gives constructive notice to all users who later file. This constructive notice removes the geographic limits of common law trademarks. Use or filing an intent to use application grants the registrant nationwide trademark rights through and enforcement privileges. 2. Federal registration gives the registrant the opportunity to use the federal courts to enforce their rights. Federal registration gives the registrant certain statutory rights. The Lanham Act provides the basis for a national registration system and protecting these rights. The Lanham Act allows service marks and prohibits deceptive marketing of goods and services. There's also an intent to use provision of the Lanham Act, which allows applicants to register marks that have not been used yet and preserves a person or entity's rights to a mark as long as the mark is put to actual use within the statutorily prescribed periods. You can also trademark your website domain name. A number of states have anti-dilution laws. All states also have statutes providing a trademark registration system, procedures for dealing with trademark disputes, and court developed common law that prohibits unfair competition. State trademark registrations are most important when the mark is only used within your state. The fees to register a mark in your state are relatively inexpensive compared to federal registration fees, and vary depending on the state. Many state trademark registrations don't offer a presumption of ownership and validity even in their own states. Common law trademarks can only be enforced within the geographic area in which the commercial activity is conducted. Therefore, it is possible at common law that A's use may be before B's use in time, but B would have superior rights if B used the mark first in a geographic space or with a specific product. A summary of distinctiveness is no trademark by which the goods of an applicant may be distinguished from the goods of others shall be refused registration. A trademark has to be distinctive if the trademark is to serve as identifying the origin of goods and avoid confusion, deception, or mistake as to the source of the goods. The trademark must be recognizable, identifiable, and different from other trademarks. Only certain trademarks are afforded legal protection depending on their classification. Mark can be classified as either 1. Arbitrary or fanciful. 2. Suggestive. 3. Descriptive. Or 4. Generic. Please email me at general@patentportfolio.com. Give me comments and ask me questions on this video. You do the same on my social media accounts. patented profiler on Twitter, Instagram, and Facebook. Stay tuned for the last free video on licensing. Thanks for your time.